Hello friends, I am Advocate Arpit Saxena. You are most welcome at my YouTube channel Rampup. Today I am going to discuss a very important difference, that is the difference in between the cognizable and non-cognizable offense. This difference is very important to understand the criminal law CRPC. So let's start the video. First of all, I would like to tell you about the first schedule of the CRPC. This schedule is very important. By study of this schedule, you can easily understand the nature of the offenses. But such offenses must be defined in the IPCs because this schedule is confined to the offenses defined in the IPC. So by study of this table, you can easily understand that which offense shall be cognizable or non-cognizable, bailable or non-bailable. But for any other offenses which are not defined in the IPC, you have to go to the last of the schedule, and there is one important table. By study of this table, any person can get one important trick, that any offense which is punishable with less than 3 years of punishment, such offense shall be non-cognizable and bailable. While any offense which is punishable with more than 3 years of punishment, such offense shall be cognizable and non-bailable. Here one point is important, that if any other special law or any law, there is a one important table or there is a one important law regarding the nature of the offense, now that special law shall prevail over this list. So now come to the actual distinction. Section 2 clause C CRPC talk about the definition of the cognizable offense. Any offense for which police officer may arrest without warrant, such offense shall be cognizable. While any offense for which police officer may not arrest without warrant, such offense shall be non-cognizable. So in a cognizable offenses, police officer generally has a more power in comparison of non-cognizable offenses, because in a cognizable offense, police officer may arrest the accused person without warrant, without any order of magistrate. While in a non-cognizable offense, to making the arrest, police officer is required to get the order or warrant from the judicial magistrate. Here one important difference is also that in a cognizable offense, there is a no warrant is required even for the arresting or for the investigation. But in a non-cognizable offense, here the police officer cannot arrest or investigate the matter without the warrant or order of the judicial magistrate. So for the arresting and for the investigation as well, the warrant is required. Generally, cognizable offenses are more heinous and grievous in the nature. For example, murder, rape, robbery, theft, extortion. While the non-cognizable offenses are generally less grievous and heinous in the nature. One important thing, that because cognizable offenses are more heinous, therefore they affect the public at large, while the non-cognizable offense does not affect the public at large. And now, very important distinction between the cognizable and non-cognizable is that FIR is registered in a cognizable offense only. So under section 154 clause first, if you want to register an FIR, such offense shall be cognizable only. While in a non-cognizable offense, NCR is registered, not a FIR. So in a cognizable offense, FIR is registered by the police officer, and such duty to register the FIR is a mandatory. While in a non-cognizable offense, NCR is registered, and after the registration of FIR, police officer shall refer the informant to the magistrate for the order under section 155 clause 2. So these are the important distinction between the cognizable and non-cognizable offense. Hope you would like this video. So please like, share and subscribe. Namaskar. Jai Hind.